TorahCafe.com.
Three areas we explore tonight. I am not here to offer expert advice. I'm here to facilitate, move things forward. I often say when people, by the way, winning at all costs, this could have been about Jewish legal ethics, or clearly it could be about the 2012 presidential campaign. But for us this evening, I am not here to offer answers. I'm here to move things forward, to raise devil's advocate questions. I assure you, while I heard the panelists say earlier, I'm not sure if there's any areas of disagreements that we have. I assure you, I will find those areas of disagreements, because that is what I do. The first area that we'll be talking about is the lawyer and the media. The second area deals with cooperating witnesses, and your reference earlier to, trust me, it'll come up. And finally, sports bounties. And you may have heard, we'll be talking about sports bounties. One of them has to do with the NFL and the New Orleans Saints, and the fact that the NFL made a decision about the New Orleans Saints and who would and would not be able to participate. You don't have to be a sports fan, but the NFL made a decision that if you have a bounty and you go after a player and try to hurt that player and you give money, right, and the coaches give money to the players who do that, and that's a bounty and that's wrong, and they were going to regulate it, the NFL was going to come down strong. And I thought, wow, we have kids in our family who want to play sports, and I said, wow, it's terrific when the sports does that and sets the standard. I want everyone to know on Friday the whole thing was overturned and those players are playing. That'll be part of our discussion. Winning at all costs. So the first piece of video, and we have video that you will see up on these screens to generate our discussion, to kick off our discussion. The first case, the lawyer and the media, involves a 2-minute compilation clips that you will see. The Duke lacrosse case, you know the case. A nationally recognized case. You will see some lawyers talking to the media, to reporters. You will see one of the defendants talking to the media. You will see the prosecutor, Mike Nifong, talking to the media. You will see players involved in this case talking to the media. We'll discuss the questions and issues and the legal and ethical boundaries that are brought on by this piece of video. It is complicated and interesting. The lawyer and the media, the Duke lacrosse case, as my good friend Warner Wolf likes to say, let's go to the videotape.
North Carolina's Attorney General will dismiss all charges against the 3 young men. Tonight, an inside look at how the case that once looked so strong fell apart so completely.
81 indictments, 12 of the 18 jurors sitting on the
Within 2 weeks, the story had riveted viewers across the country. It seemed everyone had an opinion, and many believed the alleged victim.
They've gotten away with a lot for a very long time. Why not go home and celebrate? You don't think you're going to get in trouble?
Some of the responses from college officials fueled the fire.
Unfortunately, they're young men, and sometimes young men make bad decisions, make some bad judgments. And that's what this whole incident's about.
Just 3 weeks after the allegations surfaced, a stunning blow to the prosecutor's case. The DNA collected from the rape kit did not match any of the lacrosse players. The defense crowed.
None of the boys in that house that night are at all surprised in any way, shape, or form, because when you know you haven't done anything wrong, you don't worry about a test result.
A lot of people are asking a lot of questions, sir. Can you help us sort this out as to what happened?
But the district attorney, Mike Nifong, pressed on.
You know, I no longer get to go anywhere in my community without everybody knowing who I am.
Public opinion began to turn. The prosecutor seemed to be enjoying the attention too much.
There was pressure put on me to do nothing. Well, ladies and gentlemen, that's not doing your job.
My name is Dave Evans, and I'm the captain of the Duke University men's lacrosse team.
Dave Evans was the first of the accused to speak out and declare his innocence.
These allegations are lies, fabricated, and they will be proven wrong.
Okay, now obviously we take an edited version of that ABC tape by Ms. McFadden, but there are a lot of issues here. Mike Critchley, let me ask you this. I've seen you many times in the media, but you pick your spots. Question. I know it's on a case-by-case basis, but it seems to me that there are lots of issues that you consider as to when you will speak to the media and when you will not speak to the media when you're defending a client. What conditions would cause you to say, yes, this is a smart, right case where I'm going to talk to the media because there's very little downside? Go.
Well, you do a couple things. What I do is initially I will deal with the client when he comes in, and often the client comes in and say it's a prominent politician or businessman. It's the most emotional time of his life or her life, and you have to provide some emotional support. If you have the newspaper articles on page 1 accusing your client of all kinds of wrongdoing, and you say no comment, that does a lot of damage to the client in many ways, emotionally and otherwise. And also, you want to make certain that people around him realize that he is or she is going to put up a defense, and they don't abandon you. But then you also have to be concerned about the reporter. All reporters are different. You have to determine whether it's a case of local importance, meaning a municipal matter, state importance, or national importance, and you deal with each one differently.
Follow up. Judge, do you think when a defense attorney, and also, let's say, a government prosecutor, in this case, Mike Nifon, do you think that when they are talking to the media, in many ways, they are trying to talk to you directly, or those sitting in a judge's position?
No. I think that, that both the defense attorney and the prosecutor know perfectly well that any judge who is reasonably experienced is totally immune to that kind of media attention and those media efforts. Certainly in federal court. And I don't think that there'd be the slightest interest in trying to influence the court.
I want to be clear.
Media.
I'm sorry for interrupting, Judge. You are saying that even having cameras in the courtroom, by the way, can anyone imagine a judge performing differently, acting differently, deciding differently, behaving differently, having a, let's say, judicial temperament that would be different, with cameras involved or not involved? That's an absurd premise, correct, Judge?
That's a different question. We're talking about cameras in the court. Cameras in the court changes the dynamic for everybody in that courtroom. And that's one of the reasons why I think that if you take a look at the federal judiciary as an institution, they have been generally strongly opposed to any cameras in these trial courts.
Well, you said that's a different issue, correct? That's a totally different issue. So the judge not influenced by the camera in the courtroom, but you say absolutely no influence with an attorney, prosecutor on behalf of the government, or a defense attorney trying to communicate to the media, talking to a reporter, getting to a judge, no impact, no influence.
I would say as a general rule, yes, and I think if you talk to Mike Critchley, his view would be that what he's doing would be not in the least bit directed at having an impact on the court.
Rabbi?
I'm tempted to say no comment, but but I think that while these media attempts rarely influence the judge, very frequently there's an attempt to influence the jury. And you have to be extremely careful from a Jewish perspective that you're not putting your thumb on the scales of justice in ways that influence the process outside of the way it's supposed to run.
For instance?
It's very frequent that the media attempt is an attempt to influence the jury pool, particularly in municipal matters, particularly where the trial is local and the local media coverage is very intense. It makes it virtually impossible to get an unbiased jury, for sure. And even though you're not influencing the judge, frequently the judge is not the finder of fact. I think the Jewish tradition very much wants the finder of fact to be neutral, and tampering with the jury in this way avoids that neutrality.
Mike Critchley, is that I'll use the rabbi's word, is it quote-unquote tampering with the jury to give a media interview that potentially could influence the jury on behalf of your defendant. Is that tampering with the jury?
Well, absolutely not, number one. But number two, you have to be governed by the rules of professional conduct, which limit attorneys as to what they can do. They cannot say anything that will materially prejudice an adjudicated proceeding. But you do have a right, as an attorney, to meet negative publicity with an appropriate response. That's sanctioned. But to pick up on what the rabbi just said, as a defense attorney, my job, appropriately, is to put my thumb on the scales of justice, to make certain that my client is not run over by a large behemoth called the government. And the arsenal of weapons that they have to destroy somebody is indescribable. So when I'm dealing with the opportunity to present to the media my client's case, I'm mindful of a couple of things. For the most part, on a local matter, I don't mean to disrespect any reporter in the audience, but for the most part, they're lazy. So when you see an article about a trial, you'll see maybe 2 or 3 paragraphs that change. The body of the article is always the same. And often the first article or articles drive the rest of the articles for the next year and a half. And if you do not get your story in the first or second article, often your story is not told, because you have string reporters who come into the case. They may not be the first one in, they may not be the second one in, but they read the articles and they just piggyback on what everyone else says. And you also have to be mindful that if you leave this to the government, and the government has opportunities to engage in legal as well as illegal leaks, if you leave it to the government to deal with the media and you're by yourself, the jurors now Google everything. They're Googling your client's name, and if all they see is negative publicity about your client, you're doing your client a disservice. All I'm saying is that you deal with the media, you deal with it appropriately within the bounds of the rules of professional conduct.
Mike Christie seems to be saying you absolutely have an ethical responsibility. An ethical, and if I'm wrong, Mike, you will tell me.
No,
I believe Mike is saying you have an ethical responsibility to deal effectively, manage the media process, because it's being managed by others involved in a legal case. And if you do not effectively manage the media process on behalf of your client as a defense attorney, there are some ethical and professional questions associated with that. It's weak defense.
Exactly. You have to always effectively represent your client, and that often deals with representing your client outside as well as inside the courtroom.
Reaction?
I accept that response. That response sort of is that you have to play defense. But consider a different system. Would we be better served in the United States if we moved to the Canadian model of no pretrial publicity at all, neither by the prosecution nor the defense? Would we have a more just system? I think, of course, to the extent the prosecution either speaks to the media or leaks to the media, the defense has no choice but to do the same. But let's step a little bit farther back and ask ourselves, would we have a more just system if we had a firm absolute rule, as Canada does, as the UK does, other Western democracies? We're not talking here about China and the Soviet Union. Simply a rule which says the media doesn't report on pretrial matters in order to avoid the problem of people being judged in the media. Maybe that would be a more just system. Ultimately, the Jewish tradition is very worried about the justice of the system, more than the right to publicity, either by the government or by the defense. I accept, of course, the need to defend, but that doesn't address the question of whether the system would be better if we didn't allow any pretrial publicity at all.
Judge, is that practical?
Not in the American system. In short, in the American system, one of the highest, most significant values that we have is a free and open court system. And that the press, in fact, has the opportunity to gain access to information about what's happening in the courts and provide information to the public. And to a certain degree, that in fact is regarded as a safeguard of the judicial system, because we don't operate behind closed doors in camera, but in fact that the public and the press have the opportunity to see and hear what is happening in the court system.
What about a case like the district attorney, Mike Nifong? And I don't know how many of you really remember the way Mr. Nifong handled himself, but I mean, I happen to write about that case in a book that I wrote on crisis communication, and a case study on the Duke lacrosse situation. And I was struck by Mr. Naifong and the charges that he made in public that he never took back. He never cleared the name of anyone. Never. And it just struck me when, and by the way, Mr. Naifong was running for public office. Sometimes prosecutors run for public office, and sometimes they are appointed. That does not make it not political. It means it is not electoral in terms of public voting. Government prosecutors play in the media as well. And with Mike Naifong, who made all sorts of accusations in the press, most of which were unfounded, what responsibility is there for a government prosecutor to clear the names? An ethical responsibility, an legal responsibility to clear the names of those who have been maligned publicly in the media, in cases like this and others. Your thoughts, Judge?
Well, I think I'd start off with the first problem with Mr. Naifong, which is, what is the role of a prosecutor with regard to the media?
Sure.
Which is, in my view, very minimal. In short, a good prosecutor is not a media hound. A good prosecutor is not, in fact, someone who's, in fact, trying to garner public acclaim and trying to seek public applause. The best prosecutors, in fact, regard themselves as professionals. If somebody is charged with a crime, there is a bare-bones announcement of the crime, of the charges, and that's it. I am a firm believer in the fact that, indeed, the roles of prosecutors as opposed to defense lawyers are very different. The prosecutor is, in fact, a representative of the United States government, and that obligation in the first instance is to make sure that justice is done and to represent a client who never asks them to do anything wrong. And if they can't do that, they've got no business in the job.
Michael.
Yeah, when we deal with ethical issues and we deal with people who have problems with ethical issues, we're always dealing with lawyers who are always playing at the margins. For the most part, all of us who practice law, these issues don't ever come up because, for the most part, we're all, hopefully, attorneys who practice the way we're supposed to practice, with integrity. But we do have situations, and from my experience dealing with government officials, for the most part, government officials act the way they're supposed to act, within the bounds of propriety. Some prosecutors who play on the margins, and those are the ones you have to worry about. And obviously, I'm not concerned about a prosecutor's press conference about charges. Prosecutors are very skilled in what they can and cannot say. And very rarely do you see a prosecutor, except a rogue prosecutor, go off script in terms of what RPC 3.6 says he or she is allowed to say. What concerns me is not the prosecutor standing in front of the courthouse making a bland announcement, is those subparagraphs in an article where it says, law enforcement sources say, and they're unidentified law enforcement sources who are putting all kinds of prejudicial information into the article that a lawyer cannot do. And we as lawyers, the question I have is, when this is done, where are the government officials who have a responsibility for their agents to make sure these things don't occur?
Are those ethical issues, Mike?
Oh, they're ethical issues because it's my position that a lawyer, obviously, is responsible for the acts of his agent. The RPCs talk about that. And when you're dealing with law enforcement officials involved in investigation, they are the agents of the prosecutor. And I'm not trying to say that this happens all the time. It's very, very rare. But if it happens one too many times, it's dangerous. We talk about the Naifong case. What's more alarming to me is the Stevens case. I mean, Naifong was a case in North Carolina, took on national importance. Some young men were accused, ultimately acquitted. But you talk about Senator Stevens, one of the most powerful figures in the United States, being prosecuted in Washington, D.C., represented by one of the most powerful law firms in the country. And they abused him. And I'm just concerned that we have to make certain that the prosecutors do their jobs, not only in terms of what their individual responsibilities are, which they always do, but make sure they police their agents.
Quick question in terms of, I mean, as someone in the media, I've noticed that our producers, we have booking producers who get calls all the time, excuse me, from public relations folks who try to get their clients booked on our program. Even on public television, that happens. And I am struck by how many lawyers try to get booked on our program. As soon as a case hits, you would be amazed at how many emails get sent out about lawyer XYZ, Mary Smith, Jim Jones, whatever, that he or she is an expert on whatever subject and they are out there ready to talk about it. And that's fine. But what begins to concern me is that, again, the Sandusky case gets complicated, and we'll talk about Penn State a little bit later, but not with respect to the details of that case. But as I watch the attorney representing Mr. Sandusky, legal professionals will judge the competence of that defense, not me. But as a media performer, he was horrific. He presented himself in a buffoon-like fashion. And I asked myself how much of what he was doing was an effort to promote himself. And the larger question is, Rabbi, what ethical issues are there for the legal community, for the Jewish legal community, for attorneys who are more concerned about building their own brand, building their own firm, getting their own name out there, than they are about representing their clients? And isn't there and aren't there cases where those two interests collide?
Of course these interests collide. Almost any professional who's both working for a client and seeking to build a business has almost no choice but to ask himself, how will this reflect on my next client? And that's an ongoing tension that all of us as professionals live with. We try to perform well, not just for the client in front of us, but for the many other clients that are watching. But a lawyer owes his first and foremost responsibility to the client who he's representing right now. And the idea that you'll represent a client with the eye towards future clients, maybe even sacrificing this client for the sake of a future client, I think is an intense violation of basic rules of justice. And basic rules of justice simply shouldn't ever be violated.
Judge, under what conditions have you, should you, will you bar lawyers from speaking to the media? What causes that?
Well, I've never done it, and quite frankly, I think that it would be an extraordinary situation where I would do it. Again, you're dealing with different courts, different jurisdictions. The rabbi was talking about, jury panels being influenced by media and so on. Generally speaking, for example, in federal court, the actual possibility of media contact impacting a juror pool and making them prejudiced is an extraordinary situation. With all due respect to the media, most members of the public, when they take a look at the newspaper, gloss over things very, very quickly unless they are indeed extraordinary media events.
How about TV? How about television?
I think even with TV, that unless it gets consistent, repeated coverage, it goes into the subconscious. And what I've always been amazed about is, in fact, how cases where I've seen it in the media, I know it's gotten media coverage, get virtually no reaction at all from the juror pool when they're questioned about their knowledge of the case.
Mike, go ahead. I guess I got a quick follow-up on the media and...
Just picking up what Rabbi said before, he'd love to see the Canadian system implemented here. Obviously, we have some First Amendment issues with that. But addressing the question that was addressed to Judge Schessler, I would love nothing more, because the judge is in a unique position. The judge is in control of the courtroom, and the judge's primary responsibility is to make certain that justice is done. We as attorneys can be regulated by the court to make sure we do not do anything to interfere with the integrity of the proceedings. I, for one, for the most part, would love to see gag orders issued, because I cannot compete with the government and their ability to manipulate the press. So I would say, okay, at the start, if there's a gag order issue, I would be for it.
You would like that?
I certainly would, because Steve,
Mike, as good as you are with the media, you think that's a level playing field?
And at the risk of being investigated tomorrow, you don't know how good the FBI is. I mean, the FBI has far more sources than I do. And you got to remember, the reporters are out there, they live off of leaks. They live off of information. Every day they have to put an article in the newspaper. I can't supply that raw material. An FBI agent can.
Final quick one on this, Mike. Given the importance of the media in certain situations, Judge, even though I know that you and your colleagues are not influenced by this, but juries may be. Mike, again, you do know what I'm talking about when you saw Sandusky's lawyer, and by most reasonable accounts, he was bad in public. And I'm being kind. Do you encourage your colleagues to get trained and become effective in terms of engaging the media, because there is an art form here?
Yeah, I don't know you can train them. You either have that ability to put your thoughts in a few words, because you got to remember, you can't give a 12-paragraph statement and get it in. In that 12-paragraph statement, you're going to get maybe a sentence. So you have to make certain that you have a sentence that's punchy enough, that provides the impact you want to provide, and that's something that requires understanding the file. After that, you have to get a good, if you can afford a good PR person, to my mind, they're only worth their money for the following reason: if they know the reporter. I mean, if they know the reporter, then you're guaranteed somewhat of a favorable article. If you don't know the reporter, then it's just pot luck.
Well, one second, Mike. You were implying that knowing the reporter could have an impact on the actual coverage, but there are ethical implications from as a journalist, I'm appalled at the statement that you just made. I can't believe the implication.
I guess I'm
Are you doing something on the ethics of journalists in the Jewish community? Because I'd love to. Italian-American journalists have issues too. I want to assure you.
Out of bottom. Everything except for because Steve is right, fair and balanced, just like Channel.
Okay. Yeah, everyone at PBS, we take an oath. We are not influenced by anyone or anything, but contributions could be sent to